The Federal High Court in Abuja has held that the order prescribing the pro-Biafra group, the indigenous people of Biafra, IPOB, subsists despite an appeal against the prescription order. Justice Binta Nyako, in a ruling on Friday on Kanu's preliminary objection, held that although IPOB has appealed the order prescribing it, the order remains until it is set aside. Thank you very much for joining us. This is Serious Matters on ONIF TV, and of course, I'm traveling down to the IPOB issue land where they have, they're saying they want to be on their own. They want to, they want Biafra. I want to travel there, and see, tell you what things are happening from that side. Now, this Justice Binta Nyako, in her ruling, she said the issue is still on appeal. The order prescribing the organization is still subsisting until it is vacated. A former chief judge of the courts, Justice Adamu Kafarati, who is now late, in a ruling on September 2017, granted an ex parte application by the federal government declared IPOB unlawful organization. Justice Kafarati, in another ruling in January 2018, rejected an application by IPOB seeking the vacation of the prescription order. Also, in a ruling on Friday, Justice Nyako faulted claims by lawyer to Kanu Mike Uzehome San that the IPOB leader was unlawfully renditioned from Kenya, I beg your pardon. Uzehome, I beg your pardon, had argued that Kanu was abducted and forcefully brought to Nigeria in violation of known human rights provisions. He's trying to prove that point, but the justice is not taking it that he was abducted. Well, the IPOB people will tell us whether he was abducted or not, because that's what the lawyer is proving to us, that he was actually abducted and forcefully brought into the country. Well, he's saying that the IPOB remains a terrorist organization and Kanu Nnamdi a fugitive. That is what the justice is saying. Now, similar arguments formed the subject of a 50 billion naira suit filed for Kanu on Thursday by Uzehome, before the Federal High Court, Abuja. Justice Nyako, in her ruling on Friday, said Kanu, remains a fugitive because of a bench warrant against him. She said renditions for the purpose of criminal investigation is allowed. In the instant case, there is bench warrant on the defendant. Suffice it to say, he is a fugitive before the courts. Now, the judge further held that as against arguments by the defense, her court is clothed with the requisite jurisdiction to try Kanu for offense he allegedly committed outside the country. That's strong. Yes, because that means even what he did outside the country is the court. That our court has the strength, has the power to try him based on that. Justice Nyako held that the affected counts do not disclose any offense against Kanu. The judge said in this instance preliminary objection application, I have read the counts and come to the conclusions that counts 6, 7, 8, 9, 10, 11, 12, and 14 have not disclosed any offense against the defendants. Now, count 1, 2, 3, 4, 5, 8, and 15 show some allegations which the defendant has to answer. So, like I said at the beginning, he's getting free gradually. The court shall proceed to try the defendant on those counts, she said. The judge later entertained arguments on the bail application filed for Kanu by his lawyer. Well, the judge, his lawyer, Uzehome, while arguing the bail application, contended that until a person is tried and convicted, he should be allowed to walk free. He argued that in view of the presumption of innocence, his client is innocent until contrary proof. or contrary is proof. Ozekome prayed the court to admit his clients to bail and release him to his custody. Prosecuting lawyer Magaji Labaran urged the court to refuse bail to the defendant, noting that the IPOB leader had violated the earlier bail granted him. Of course, I know that's what they're going to leverage on. Labaran said, my lord granted him bail on 2017 on health condition or health grounds. But since then till date, no medical record was submitted to the court until he jumped bail. What we should be saying is contempt of court because he has flagrantly violated the orders of the court. He stressed that the court should be guided by its discretion, particularly the circumstances of this particular case. Labaran added that in the alternative, the court should order accelerated hearing in the case so that the defendant could know his fate on way or the other, whether he will be freed or Justice Iyekwa adjourned the case till May 18th for ruling on bail and May 26th for commencement of trial. Well, now so we say amo. Now so we say amo. You know, make they give you updates as the thing they go. They talking for my place say if the lies no finish for head, say blood no they finish for fingernail, that means say you go still just the pick and they do. So at least some of the counts is the charge where they put against Nnamdi Kanu, they don't remove them, you know, but the remaining they go still talk about them. Well, make we see as everything go be, you know, as we they see, as we they follow the matter, they go drop your comments, they make them simple and civil. You know, I will wait to, you know, respond to any question where you want ask us from this side. Thank you very much. This is Serious Matters on Top ONIF TV.